is a hugely important. Yeah, and this is a very important section of amendments as far as we're concerned. It's a large group, and we'll deal with aspects of it, I suppose, between us in terms of information being admissible in court, and then some more issues around the question of apologies. Now, in our view, Section 10 requires a huge amount of amendment, and to be honest, we were very disappointed that these issues were defeated at committee stage, because Section 10 holds that neither information provided nor an apology made during open disclosure will be admissible as evidence in court in regard to any action that arises from the patient safety incident that has been disclosed. It also holds that information provided and an apology when it's made will not be admissible as evidence of any professional malpractice or misconduct in a professional misconduct investigation. Now, as we said at second stage, the idea that factual information provided at an open disclosure meeting would later be denied by a health service provider in court is absolutely mad and contrary to the principles of natural justice. As the Medical Injuries Alliance have pointed out, it will be abhorrent to the administration of justice for a court to be precluded from considering all existing information necessary to establish relevant facts before making a decision on questions of liability. There is a huge issue here also in that this proposal to prevent a patient from being able to rely on any information provided during an open disclosure process is actually likely to breed more distrust than less. I mean, if, for example, the patient is provided with a clear and frank explanation of how an adverse incident occurred, and then later in court the very same facts and version of the events are denied by the service provider, what's that going to do for building trust in our health service? There's obviously less difficulty with the proposition in the bill that information provided pursuant to the legislation cannot be deemed to constitute admission of liability in the legal sense. Therefore, we've actually left that in. We don't have a problem with that. It's not about so we've left Section 10, subsection 1 intact. Our amendments also retain the protection for apologies that are currently in the bill, so we're not removing that either. Apologies can't be submitted as evidence of liability, and we'll make some points on that in a minute. But really what we want to do here is to emphasise the point that where there's a dispute on liability, it's essential that the court is able to consider all factual evidence gathered on foot of the incident in question, and that includes any facts obtained during open disclosure and all records created for the purpose of making that disclosure. And we need to look at this in the context of court proceedings, and we should say that allowing information and records to be given over that were as part of an open disclosure process to be entered as evidence in court proceedings doesn't necessarily mean that those court proceedings are going to succeed. All the legal safeguards that normally operate in these situations are going to remain anyway. That's because even if the information and documentation gathered as part of the disclosures process was admissible as evidence of fact, the patient would still be required to establish liability absent a formal acknowledgement or admission of same. So the question of liability still has to be determined. We're only talking about access to factual information, and we believe that this provides ample protection to the service provider, particularly when you consider that the burden of proof which a patient has to discharge in any civil action is a very, very high one. It has to be proven that the doctor has been guilty of a failing for which no other reasonable doctor of like skill or experience would be guilty. So it's a really high threshold. There's also a huge issue here in that if information is gathered or provided as part of the disclosure process can't be admitted as evidence in court, it's going to make court cases much longer and more expensive. Tom Ryan of the Irish Hospital Consultants Association, in his submission to the Oireachtas Health Committee pre-leg scrutiny hearings, said when litigation does occur, it's preferable that it should be conducted speedily. We know the state already spends tens of millions in fighting damages claims, as do indeed the individuals involved in these claims. We know the shocking fact that the state spends more on fighting clinical damages claims and paying out damages than it does on the entire amount of money it spends on our maternity services. And if the provisions around open disclosure, as currently constituted in the bill, are allowed to stand, we believe that it's likely that there's going to be an increase in litigation costs, because if one party to a civil case has access to relevant factual information and the other party is denied access to that relevant factual information, well then legal battles are going to be more hard-fought, they're going to be more lengthy and more costly, apart from the emotional and psychological damage to the people who are already victims in these cases, because without our amendments, patients are going to be forced then, in the absence of being able to use that independent factual information, they're going to have to go out and get their own and pay for their own independent medical experts to give the expert evidence needed in order to substantiate or establish substandard care and causation there, something which the already established through the open disclosure process, that they shouldn't have to go through that extra leg to get that. And I really think the system is very deficient in that. Obviously, some similar provisions around dealing with information in relation to professional misconduct hearings, and again we believe that factual information should be given there. These hearings are obviously not as onerous as those in a civil action, so again we think that there's really no reason why that couldn't be done. I suppose the last point I'll make, Count Corla, is, if you like, the Francis report in Britain, which led to the establishment of the UK statutory duty of conduct. The QC involved in that, Robert Francis, reasonably made the point in regard to professional misconduct proceedings that professional regulators would be far more lenient on those who owned up to errors with a serious effect on patient safety than they would with those who denied it or tried to cover it up. And he said, we need a situation where the legal advice is going to be, I know this is unfortunate, but you're going to be better off by telling them about it and being honest and open about it rather than not. And he's exactly right on that. And we have a long, long way to go to get anywhere near that. But denying people access to factual information which they know and were told about in an open disclosure process later on in civil proceedings is an incredibly big flaw in this bill.